Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. We got huge news out of the Fifth Circuit earlier this week, and I do mean huge. This has to do with a challenge on the handgun bans as it relates to 18, 19, and 20-year-olds being able to or not able to actually purchase handguns. As we know, we've kind of been going through this long soul searching where we're going through a lot of old statutes, many of which had constitutional challenges previously brought against them, were found to be constitutional under the old two-part balancing test. But upon a second look, a instant replay, if you would, according to the new test, we're beginning to see that a lot of these laws, well, they just don't stand constitutional muster anymore. And this is another classic example of a law that has for long since been held constitutional, which has now finally been struck down. So today, let's spend a few minutes and let's talk about a huge ruling that could benefit millions.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.
Okay, America, the case we're talking about today is called Reese versus ATF. It is a newly published opinion from the United States Court of Appeals for the Fifth Circuit. It is a ruling which holds that the federal prohibition on 18, 19, and 20-year-olds being able to lawfully purchase a handgun is in fact unconstitutional. Specifically, the laws that were challenged here included 18 United States Code Section 922B1 and 922C1. And for those of you who are stuck in the age of purgatory, 18, 19, or 20, you will know that these are the federal laws that prohibit any FFL from selling you a handgun. Now, as the plaintiffs in this particular case outlined the issue to the Fifth Circuit, it was, appellants contend that the federal laws unconstitutionally infringe on their right to keep and bear arms under the Second Amendment and deny them equal protection under the Due Process Clause of the Fifth Amendment, which, of course, as we now know, the Fifth Circuit has found is unconstitutional in its application to 18, 19, and 20-year-olds. Now, the United States government came up with some rather offensive and desperate arguments, as they oftentimes do when they're on the short side of history, as they oftentimes are. The court had to point out, addressing the first question under Bruin, the government contends that the Second Amendment's plain text does not cover the conduct that Section 922B1 and C1 prohibit. The government argues that a limited ban on the purchase of handguns from FFLs is not an infringement on Second Amendment rights, and in any event, 18 to 20-year-olds are not among the people protected by the right. Now, I want you to think about that for a second. 18-year-olds, they can vote. They can also join the military and die for our country. And the United States government believes, however, that they actually don't have Second Amendment rights because they are not part of the people. The very individuals willing to put their lives on the line for our freedoms are not part of the people. It's literally as offensive an argument as you could possibly think of. We reject these points and then move to Bruin's second inquiry, whether the government met its burden to demonstrate historical analogs supporting the challenge regulation. So as you can see, the Fifth Circuit obviously was not particularly persuaded by that rather ludicrous argument. Now, one of the other things that the United States government argues, and I want all of you to be aware of this, especially when you're in these states where they're putting all sorts of crazy conditions now on the ability to acquire a firearm legally, is that, hey, listen, the Second Amendment only protects the right to keep and bear arms. It says nothing about the ability to acquire firearms. That is literally an argument that the United States government made, and you're going to see that argument from a lot of other of these gun-grabbing states. Well, the Fifth Circuit wasn't too persuaded when they ruled, contrary to the district court's assumption, the government denies that the plain text of the Second Amendment establishes a right to purchase firearms at any time from any source. It emphasized that Section 922B1 only limits the sale of handguns by a particular type of seller to a particular class of buyers. Of course, the words purchase, sale, or similar terms describing a transaction do not appear in the Second Amendment, but the right to keep and bear arms surely implies the right to purchase them. And perhaps one of the biggest rulings to come from this particular case, and I want all of you to put this in your memory bank when you got your states out there trying to do license to purchase or mandatory insurance before you can purchase or things like that, is when the Fifth Circuit ruled, the threshold textual question is not whether the laws and regulations impose reasonable or historically grounded limitations, but whether the Second Amendment covers the conduct, commercial purchases to begin with. Because constitutional rights impliedly protect corollary acts necessary to their exercise, we hold that it does. And the court was quick to also point out, to suggest otherwise, proposes a world where citizens' constitutional right to keep and bear arms excludes the most prevalent, accessible, and safe market used to exercise the right. The baleful implications of limiting the right at the outset by means of narrowing regulations not implied in the text are obvious. Step by step, other limitations on sales could easily displace the right altogether. And that is immensely important, America, because as you begin to see more and more of these states put up as many possible roadblocks humanly possible to the acquisition of firearms, if they are allowed to continue to do that, they will ultimately be able to eviscerate the underlying right altogether. Now, as you know, the government came up with this very ludicrous and very offensive argument that 18, 19, and 20-year-olds are actually not even part of the people. How did the Fifth Circuit deal with that? Moreover, in the unamended Constitution and Bill of Rights, the phrase right of the people appears in the First Amendment's Assembly and Petition Clause, the Fourth Amendment's Search and Seizure Clause, and the Ninth Amendment. All of these references confer individual rights and undoubtedly protect 18 to 20-year-olds as much as 21-year-olds. In fact, with modifications, the rights they confer extend to younger minors. The court was also quick to point out, from another angle, in all 6 other provisions of the Constitution that mention the people, the term unambiguously refers to all members of the political community, not an unspecified subset. Now, the government, in its desperation, came up with some pretty crazy arguments, including that if you go way back in time and you take a look at who was considered as part of the people back then, in many instances, 18, 19, and 20-year-olds were not. Guess who else was not included way back in the day in the calculation of the people? That's right, African Americans. Yeah, you see, because way back in the day, not only could 18, 19, and 20-year-olds not vote, but neither could certain ethnic groups, including all of the people that we had forcefully brought to this nation under the guise of slavery. And as the Fifth Circuit pointed out, this argument is incompatible with Second Amendment precedent, nonsensical when considered against the backdrop of American suffrage, and contradicted by the history of firearms use at the founding. And that is important because when we take a look at the formation of this country and we take a look at who served in the militias, it wasn't that 18, 19, and 20-year-olds were allowed to serve in the militia. It's that 18, 19, and 20-year-olds were expected to serve in the militia. And when you were expected to serve in the militia, you were also expected to be armed with the most modern firearms humanly available. And so the Fifth Circuit was very wise. And this is really important to point out that, listen, even though certain constitutional rights may have only encapsulated a certain segment of the population back in the day, it does not mean that those constitutional rights do not encompass a much larger swath of the population in modern times, as the Fifth Circuit put it. Although its meaning is fixed according to the understanding of those who ratified it, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. And then again, if we're going to really dive into the history, we take a look at, were 18, 19, and 20-year-olds allowed to serve in the militia? They most certainly were. As a matter of fact, they were expected to serve in the militia. And of course, if you were expected to serve in the militia, you were expected to come armed. As the Fifth Circuit put it, finally, the history of firearm use, particularly in connection with militia service, contradicts the premise that 18 to 20-year-olds are not covered by the plain text of the Second Amendment. After Heller, there is no doubt that the militia was a subset of the people protected by its operative clause. The 1792 Militia Act, in turn, shows that 18 to 20-year-olds not only served in that militia, but were required to serve. So, in reaching this ultimate conclusion that the federal prohibition against 18, 19, and 20-year-olds lawfully acquiring handguns from FFLs is unconstitutional, the Fifth Circuit has ruled. Ultimately, the text of the Second Amendment includes 18 to 20-year-old individuals among the people whose right to keep and bear arms is protected. The federal government has presented scant evidence that the 18 to 20-year-old firearm rights during the founding era were restricted in a similar manner to the contemporary federal handgun purchase ban, and its 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. In sum, 18 United States Code Section 922B1 and C1 and their attendant regulations are unconstitutional in light of our nation's historic tradition of firearm regulation. We reverse the district court judgment and remand for further proceedings consistent with this opinion. A huge win. Congratulations to all the named plaintiffs in this case, and in particular, the Second Amendment Foundation, who absolutely knocked it out of the park with this case, which means, of course, we're going to put a link down below so that all of you can show them some love. Now, does this mean tomorrow, if you're 18, 19, or 20 years old, you can just go run on out and buy yourself a handgun? Oh, absolutely not. No, come on. We all know the wheels of justice turn amazingly slow. The United States government is obviously, in all likelihood, going to crap its pants and appeal this. Now, maybe we'd see something different now that we've had a change in the administration, a new attorney general coming in, a new ATF director theoretically coming in. But right now, I do expect the United States government to appeal this. Whether the United States Supreme Court is going to want to accept this, that remains to be seen. So this case is a long way from over, but for now, this is a huge, and I do mean huge, win. The case, once again, is Reese versus ATF. We're going to link it up down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.